Joseph Anthony Ochoa. Counsel, is this a first setting for your client?
It is, Your Honor.
All right, where are we on discovery?
The discovery's been made totally, I mean, I've had access to it. And so there's no issues with discovery.
All right, state, did you tender an offer?
Yes, we have, Judge.
All right, Ms. Ferguson, I need a plea deadline date. Sir, how old are you?
39.
All right, and these are third-degree felonies in state jail?
It's 2 second degrees and 1 first degree habitual as their.
Oh,
I'm
yeah,
sorry, it's third degree habitual, I'm sorry.
okay, I'm sorry. I don't have your indictment before me, so I don't know if it's habitual or not. So, let me see.
So to clarify, it's 2 state jails enhanced with the TDC sentences to second degrees and 1 third degree enhanced
Enhanced
to
to-
habitual.
Habitual.
As a habitual. All right, we're going to recall this in 30 days. That will be your plea deadline date. If you don't reach an agreement on that date, then your next date will be a jury trial date. All right, I need a 30-day plea deadline date on Ochoa.
February 19th.
All right, and counsel, if you'll do an acknowledgement of discovery.
Okay.
All right, then after that, you're excused. Do you have any questions? All right,
Thank you.
we'll see you then.
Thank you.
Thank you, Judge.
Martin Mendez. All right, do y'all have an acknowledgement of discovery? I'm sorry, not an acknowledgement of discovery, a trial court certification?
No, Your Honor, I just been appointed this morning, a few minutes ago,
Okay.
on his case. It's an MTR.
All right. Ah, because he's the Spanish speaker, correct?
Correct.
You're on this side. This is a Spanish speaker.
Oh.
So next time he's before me, I need an interpreter. All right, this was actually set for a contested hearing. This is going to be recalled for a contested hearing in 10 days.
All right.
And the violations, you've now had a chance to review those.
Right.
So recall this in 10 days for a contested hearing. January 26th, state you need to be prepared for a contested hearing. All right, thank you.
Oh, I'm out of county, Judge, in another case previously said.
I'm sorry, what?
I am out of county in Care County on a previously said case.
All right, Ms. Ferguson, he needs another date.
If I can have the 29th.
All right, 29.
Thank you, Judge.
Thank you. Damian Antonio.
Right here, Your Honor.
And that's a PTD.
It is, Judge. You got the contract?
Damian Antonio, come up,
Oh.
please. And has the contract been completed?
Yes, we just signed it today. They changed the procedure a little bit. They want us to scan and email it. So as soon as we get back to the office, I'll have it over to them within the hour.
All right, I need a PTD date.
I can do, February 19th.
That works.
All right, we'll see you back on February 19th. Once you sign the reset form, you excuse.
Good deal.
Thank you.
It's okay.
All right, Rita Panana. Good morning. All right, court is calling 2025 CR 010639, State versus Rita Lisa Pineda. All right, can I have parties announced for the record, please?
Lauren Espinoza for the state.
Ray Lopez for the defense.
And are you Miss Pineda?
Yes, I have.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Pineda, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Judge, I did.
Your charge is possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Pineda, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Judge.
Anyone promised you anything other than the plea?
No, Judge.
Are you satisfied with the way you've been represented?
Yes, Judge.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Judge.
According to the plea, punishment is to be assessed at 221 days in the Bexar County Jail.
Yes, Judge.
Heads up, when the judge explains the waiver of appeal and trial rights, it's a textbook example of a defendant giving up fundamental protections knowingly. This is the moment where legal literacy can literally change someone's freedom.
Under 1244, there's a $600 fine and there are no applications. Did you understand that to be your plea? Defense?
It is, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, I did, Judge.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Judge. I did.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. State offers State's Exhibit 1 in all attachments.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Judge. I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Judge.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We would ask the court to follow the plea bargain agreement, Your Honor.
And to the clerks? How much time does she have in?
She's
Okay. I'll find out how much time you have in. What I can tell you, I'm assuming that you all are asking that this be a judgment satisfied.
Correct, Your Honor.
This is what I can tell you. If I follow your plea bargain agreement, which I will sentence you to 221 days at the Bexar County Jail. If you're assuming you have a judgment satisfied because you received 2 for 1, or you're trustee and you're receiving 3 for 1, so for every 2 days in general population without any problems, for every day you receive the credit for 2 days in general population, or if you're a trustee, for every day you will receive 3 days. This is the thing about that. I'm not in charge of that at the jail. So the jail can make the decision that they're not giving you 2 for 1. What I can tell you is I'll follow your agreement. You'll be sentenced to 221 days. So once I sentence you, if the jail is not giving you 2 for 1 or 3 for 1, I have no authority to force them to do that for you. You understand? So does she have 221 actual days in or no?
No, Judge. She has 130.
So that'll be up to the Bexar County Jail. All right. So as previously stated, the court will find you guilty. The court will sentence you to 221 days in the Bexar County Jail under 1244. Give you credit for any time served. And there is a $600 fine. Time and money will run concurrently. Anything else with regards to sentencing?
That's it for the defense, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, and because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
I do.
All right, we can go off the record. Here's the thing. It appears that you may have a drug problem. And this is sort of the easy way out. You take your time and you're done. When you're released, what you need to do is you need to find some place to do sober support meetings. Those are like your NAAA meetings. They're all over the city, all hours of the day, so you can take it at any time. Because if you continue the way you are, either you're going to be back before another judge, it may not be me, it may be somebody else with another attorney, or either the last time you use may be the last time you use, and somebody's going to have to identify your body. You understand?
Yes.
If you can't find a place to go for a sober support living or something, if I'm still here, come back here. I'll pick up the phone and call somebody to help you, okay? All right, good luck to you. Thank you. All right, the parties on Shepherd Jepson, did y'all do are you all proceeding on the motion to revoke today?
I'm gonna ask for some time, may I approach?
Yes, have your client come up.
Judge, you'll remember Mr. Shepherd, right here.
Mhm.
Judge, we're requesting a 1-week reset. We have some proposed resolution to the case with Ms. Albon that would send him to the intermediate sanction facility. He has a couple of pending pre-filed misdemeanor cases in County Court 12. So I've been going back and forth this morning. We're gonna waive certain things. We're gonna file the cases, and we're set for a plea next Wednesday on the 21st. So we'd ask just that you recall this case next Wednesday. That would,
To be on a Thursday.
but that's fine. The 22nd would be fine too, Judge.
Ms. Abrams, on this case, can you see if there are any openings in felony drug court?
Yes, Judge.
And so and how long would it take for them to interview him? All right, just give us a moment. I'm gonna see how long it's gonna take felony drug court to interview him, because it may take longer than the time that you wanna be back.
Okay, Judge, thank you.
All right. And then,
Yes, ma'am.
yes, Mr. Shepherd. So here's the thing about felony drug court. Depending on what happens with your case, I keep an open mind on everything. But it appears from looking at the MTR, there are some issues. So if you're accepted in felony drug court, and you may want to call over there, they will make the determination if I were to send you there, whether you go into inpatient at ISF or not.
Okay.
Now, what I can tell you, if I order felony drug court and they don't accept you, then more likely than not, you're going to go to an inpatient facility. Do you understand? So you all need to reach out for that. So just have a moment. Ms. Abrams going to find out when they can interview you. Thank you. Andreas Hernandez, if y'all will come forward. Raphael Liel.
How are you, Judge?
Oh, I'm doing great. How's it going?
Excellent.
Yeah.
Hello, Your Honor.
Hello. So where are we on discovery on this case?
I have the discovery, Judge, and I have discussed the matter with the prosecutors. I have gotten an offer, conveyed the offer to Mr. Hernandez, and recommended that he take the offer, but Mr. Hernandez is of a different mind and wants
Well, I
to
mean, here's the
set
thing.
it trial.
If you want a jury trial, we will give you a jury trial, and we will give you a jury trial quick, fast, and a hurry. This is a possession case, so it shouldn't take that long.
Yes, yeah, and I understand. I know if I think of a jury trial, that would be 25 plus years if I were to lose. That I understand. I feel as if I don't have to go to that route, thinking I know I'm not gonna beat the case, but I feel my constitutional rights were violated.
Okay, so let me stop you there. Here's the thing. With drug cases, right? If your attorney wants to file a motion, the court will hear whatever motion they file. Now, in my experience as a defense attorney and prosecutor, with regards to drug cases, sometimes people complain because there was a search warrant. They say the search warrant was improper, right? So that's something maybe you can file a motion on. Sometimes you have people who maybe were driving a vehicle pulled over by the police, and you say the police never should have pulled me over. And I'm just speaking to you in layman's term. And that may be a reason, right? So those are usually the reasons for people are saying my rights were violated. Now, drug cases normally, and yours normally, would probably be, what is this? A third-degree felony with a range of punishment of 2 to 10 years in prison. But if you are designated as a habitual and the state is able to prove up that you're habitual, now how do they prove that up? Usually, you know what it ends up being? They have somebody send what's called a PIN packet. And the PIN packet is a packet that has documents in it that will show that you were sent to prison or something before this case, right? So if that has happened twice before this case and the state is able to prove it, then that means you're designated as a habitual. The law changed back in the day. Didn't matter how many times you had been to prison, you wouldn't be designated as a habitual. But all around the country, they started doing this 3 strikes and you're out thing, right? So with you, instead of your range of punishment being 2 to 10, if you were found guilty, your range of punishment is a minimum of 25. So that means if you go to a jury, if a jury were to find you guilty, they can't give you probation if they find.
Critical warning here. If a defendant is habitual, minimum sentences skyrocket from 2 to 10 years to a minimum of 25. This is why plea deals are so strategic. One misstep and the consequences are monumental. Always understand habitual offender laws. They're a game changer.
That these allegations are true, your minimum is 25. If you come to me for a bench trial, and what I can tell you, I've had bench trials before me where I found people guilty and I found people not guilty. If you come before me and you're found guilty on a bench trial, I can't give you probation. Your minimum is 25. And I know sometimes people are like, oh, it's just a drug case. I can't believe I'm getting 25. But that would be your range of punishment. It's completely up to you. So for your case, we'll set it for a jury trial.
Like I was gonna say, it says here that I was found with what 1 gram. I had 3.2 grams.
Oh, no. So here's the thing. You don't want to let or admit to things. You're not under oath, so you'll be fine. But this is what I can tell you about your case. Could I see the indictment on Andres Hernandez, please? They're putting you at a 3rd-degree felony because according to what I'm reading on the docket, it may be wrong. That's why I'm asking her to pull the indictment. You were in a drug-free zone.
That was on the sidewalk.
Yeah, here's the thing though, but drug-free zones, like schools are usually drug-free zones.
Yeah.
So if you're within a certain feet from a
1,000
school,
feet, that's here.
so that means that maybe if you have a possession less than a gram, it's no longer a possession less than a gram. They enhance it because you're in a drug-free zone. And when they enhance it, it becomes a 3rd degree, you become a habitual. Your minimum is 25. Now, if it's just a regular state jail felony drug case, then you're most likely looking at 2 to 20 years unless there's something else out there. So that's where we are.
So that's 44B doesn't work on this one either, right?
They're not, no.
Nothing like that, nothing like
No.
that. 44, nothing like that. Okay. Well, when they arrested me that day with San Antonio Independent School District Police, they
You're
called.
allowed to do
They
that.
called that San Antonio Police Department twice and they never showed up. So they took me to their facilities. And they took my wallet from me, they took my credit card, they took my money, and they put it inside my backpack, and they kept it in their facility. And to this
You
day,
don't have it.
to this day, I'm unable to keep my money. I'm unable to keep my credit card because.
Okay, let me explain something to you, and I want you to internalize what I'm saying.
And I thought it was a
No, no.
violation of the 14th Amendment.
All right, I want you to internalize what I'm saying, right?
Yes.
I've had clients in the past before who have told me, like they get arrested for something. Let's say they get arrested for a drug case, right? And my client would tell me, hey, Stephanie, the officer roughed me up. My case should be dismissed. They think it means it's a wash. And I tell them, the fact that an officer maybe roughed you up, that is a whole different case. We're just here dealing with the criminal case. So the fact that you're saying that the school division, they kept your license, they kept your credit card, maybe they took some money, that's a civil matter. It has absolutely usually nothing to do with the criminal case. You understand?
Never in my right either.
Here's a subtle but crucial distinction: civil claims versus criminal charges. Just because the police mishandled property doesn't void a criminal case. Many defendants misunderstand this and hope it washes out the charges. Courtroom clarity like this is a lifeline for rational decision-making.
Yeah. So that's where we are. So if you want a jury trial, I'll give you a jury trial. I'm sure your attorneys explained to you, I've explained to you what a habitual means, and it appears in the indictment that I have that you've been designated by the state. They're saying you're a habitual offender. If you go to jury trial and are found guilty, you're looking at a minimum of 25.
Okay, can I get a trial?
I'm sorry?
Trial?
Oh, sure. We'll get you your trial.
Judge, and for the record, the offer that I conveyed to my client was,
Oh, I don't need to know the offer. If you want to put the offer on the record, you can.
yes.
All right, just go ahead and go over there and yes. And I'm sorry, what page is he on again? Yes.
Felony drug court said that as long as they get the referral today, we could get him scheduled for interview on Tuesday. We just need to make sure that he is available.
I'm available, yes, ma'am.
All right. So this is what we'll do. And counsel, when did you say those other cases will be taken?
We're going to enter those pleas in County Court 12 on the 21st, which is Wednesday, I believe.
All right, so Ms. Abrams, if you'll let them know that they're gonna do that at that time. And I'm sorry, let's go off the record briefly.
Thank you, Judge.
You're welcome. And counsel, I'm assuming you're waiving the contested hearing?
Yes, Your Honor.
All right, who's next?
The last case, Judge. The add-on page, add-on question.
Arsenio. Morning, Judge.
Hi, good morning.
Yeah, we added on to potentially come in here and talk about maybe doing a plea. It didn't work out, so we're fine with our trial setting.
Okay, let me see. All right, Mr. Marcinak. All right, so my understanding is that y'all were unable to reach an agreement?
Yeah.
All right, so the plea deadline date will have expired. The court will not consider any plea bargain agreements without good cause. Otherwise, you have to plead open to the court. Do you understand?
Yes, ma'am.
All right, then my next thing is, do y'all have an acknowledgement of discovery completed?
I believe so.
We did one today. Yes, it was part of the, we were trying to work out, like, we can use that one, I guess.
I think we already did it when we got our trial setting.
All righty,
Right, thanks, Judge.
thank you. Once you sign the reset form, you're excused. I know you have a previous one, but
And we can use that one unless the court
no, all right, see you then.